by the Committee of Experts. The Parliamentary Select Committee suggested that instead Parliament should be granted broad authority to establish other courts with such jurisdiction, functions, and status as Parliament may determine. In their wisdom, the Committee of Experts overruled the Select Committee, taking the view that firstly, such a provision would give Parliament a blank check to establish courts whose level and jurisdiction could supplant the superior courts established in the Constitution. Secondly, that this would not guarantee the establishment of specialized courts on employment and land and environment, and lastly, that it would not solve the competing jurisdictional issues that had historically existed between the High Court and the Industrial Court. Thus, the Committee of Experts reinstated the constitutional provision allowing Parliament to establish by legislation the Employment and Labour Relations Court and the Land and Environment Courts with a status equivalent to the High Court as had been provided for in the earlier drafts. This took wisdom, courage, and foresight, and I'm glad that the people of Kenya responded to this courage by giving a resounding approval of the recommendation when they turned out to vote in the referendum of 4th April 2010, 4th August 2010. The express establishment of the ELRC in the Constitution solved not only the jurisdictional problem, but also helped give judges who preside over these important employment and labor relations questions the same protection enjoyed by the judges of the High Court. This then ensures that their independence in determining these disputes in a manner that safeguards employment relations at industrial level, while ensuring that at the macro level, that labor is playing its part in driving our economy and society forward. This is a backdrop against which we must reflect on the work of the ELRC over the past 10 years. This then is an open space for reflection on the court's jurisprudence and culture after a decade of existence and the jurisprudential and institutional relationships between the ELRC and courts, vertical and horizontal. Go to it. My office has readily coordinated administrative support to the ELRC, and it's been great working for the past 9.5 years with the principal judges of the court, past and present, as well as the registrar of the court, to ensure that the ELRC is properly and adequately facilitated to deliver on its mandate. Since the 2015-16 financial year, the court has been budgeted for separately from the High Court, unlike before, and its annual budget has progressively grown, and I'm proud that under the leadership of the principal judges, the court has put this money to good use. And as we reflect on the future of the court, and more specifically on how the ELC can be transformed into an instrument of achieving the social transformation that the people of Kenya continue to yearn for, I'm particularly interested in understanding what more the Office of the Chief Registrar of the Judiciary can do to facilitate and enhance access to justice in the employment and labor relations context. As I end, ladies and gentlemen, I know we will get another opportunity to appreciate our partners and sponsors, but at this point, let me just mention and appreciate the Central Organization of Trade Unions, and I think Mr. Tolly is with us here, Thank you very much. I want to appreciate the Federation of Kenya Employers, and Jacqueline Mugo is also here. Thank you very much. The Institution of Human Resource Management, the International Labour Organization, Kenya Law, Kituo cha Sheria, the Law Society of Kenya, the Public Service Commission, Sharia Sacco, the Teacher Service Commission, the University of Nairobi, among others. I hope we will all have an opportunity to go out there where they're all exhibiting what they do, showcasing their work, and we are truly grateful. Thank you all so much. Welcome again to this conference, and we look forward to great conversations in the next 4 days. Karibuni sana, and may God bless us all.
Thank you very much, the Honorable Chief Registrar, for your remarks and for welcoming the delegates and the distinguished guests to this very important conference and symposium. Let me take this opportunity to recognize the Honorable Speaker of Senate, Honorable Amason Kinge, and also His Excellency Johnson Sakaja, the Governor of Nairobi County. At this point, let me welcome Ms. Jacqueline Mugo, the Chief Executive Officer of the Federation of Kenya Employers, to make her remarks. In the interest of time, I kindly request the speakers to adopt the protocols that had already been laid out. Thank you very much. Welcome.
Thank you very much, our moderator, for making my life easier and taking away the panic that I would break protocols. So let me just recognize the Honorable Chief Justice and President of the Supreme Court of Kenya, Lady Justice Martha Koome. All protocols observed. Distinguished guests, judges of the Supreme Court, the Court of Appeal, the High Court, ladies and gentlemen, good morning. I am delighted to join you on this landmark occasion of the 10th anniversary of our court. I call the Employment and Labor Relations Court our court because FKE and other social partners fought for many years for the elevation of the industrial court, as it was known then, to the position it occupies today in our court structure. As labor sector leaders, the employers and workers enjoy a unique relationship, and they wanted a court that understands that unique relationship. The key question we always attempt to answer is, how do we protect the welfare of the workers while promoting the growth and proper functioning of enterprises at the same time? Therefore, the ELRC, as we call it, is in a unique situation where every judgment or ruling made, whether in favor of the employee or the employer, affects real lives and workplace relations. I want to congratulate our honorable judges who have carried out this noble and weighty task for the last 10 years since the establishment of the court. We are proud of the work that you do, and we appreciate the role that you play in maintaining harmony in the labor sector. The Federation of Kenya Employers stands for fair labor practices. We have always advocated for judgments and pronouncements that leave both the workers and the employers better off than when they came to court. I am happy to say that to a large extent, our court has lived up to our expectations. Of course, there are occasions when we have disagreed with some decisions on the basis that it is harmful to the proper functioning and development of the labor market and the preservation of industrial peace and harmony. For example, in the transitional period of the court, we saw some interesting aspects of the interpretation of the law with varying consequences, some of which were fatal, like when a multi-million shilling judgment on a redundancy process that went wrong sent one of our vibrant members into the abyss of business history in 2013. In such a case, it is not only the business that closes, but many workers also lose their livelihoods. In awarding the damages and compensations and meting out sanctions, we call upon the ELRC to be considerate to business and the economic realities that employers face. Honorable judges, distinguished ladies and gentlemen, as employers, we know that in the 10 years, the court has had its hits and its misses. We join the court to celebrate the achievements that it has realized and to learn from some of the challenges faced. Let me mention a few of the achievements. Inasmuch as we do not have statutory framework on new business models like outsourcing, the ELRC has come out boldly to put in place policy parameters to address this. When COVID-19 pandemic befell us in 2020, employers were gratified to see that the ELRC aligned itself with the National Memorandum of Understanding that the tripartite social partners entered into after negotiations that contained a raft of measures to secure jobs and sustain enterprises. I believe we have all witnessed the tremendous progress that all the courts have made in adopting technology, and we commend the CJ. I think they acted very fast. And this was aimed at ensuring that justice continues to be dispensed despite the challenges that we know our country faces in IT. Employers believe that this mode of work is now the new normal, given the realities of the world of work. Honorable CJ, distinguished judges, ladies and gentlemen, we want to encourage the court to investigate the misses and see them as opportunities for improvement. We can never have a perfect court, but we can always learn from the past and seek to improve the functioning of the court. Let me highlight some 5 key areas that employers think the court could consider in this journey of improvement. 1, the need to promote proportionate dispute resolution. Employers are increasingly faced with the challenge of protecting the right to work in these tough economic times while struggling to keep their businesses afloat. Balancing these rights has remained a vexing issue for employers. Such balance can only be achieved by parties respecting the judicial independence and strict obedience to court orders on the one hand, and on the other hand, being alive to the fact that we have a growing economy to protect, enterprises that must be given hope that they are not operating in isolation and that their rights will be upheld if they operate within the law. The competing interests between employers and employees often causes friction in the labor market. We rely on the ELRC to provide guidance by promoting proportionate dispute resolution and promoting social dialogue at the shop floor level. The second area is the need to promote social dialogue in resolving disputes. And here we want to commend the ELRC, again, as I've said, in leveraging on the tripartite MOU that was signed at the start of the pandemic and insisting that labor disputes be subjected to ADR before court process. We urge the ELRC to put more emphasis on alternative dispute resolution and advise parties to engage in social dialogue to resolve their labor disputes, which largely fall into rights disputes and interest disputes. We should develop to a level where the court deals to a considerable extent with disputes that cannot be resolved in ADR mechanism. The third suggestion is supporting the development of jurisprudence. There are several areas where we believe our labor laws contain inadequate provisions or none at all. For example, work from home arrangement, work rotation model, termination of employment, and payment of terminal benefits occasioned by redundancy. The Federation's members are concerned about what they see as attempts to muzzle the jurisdiction of the ELRC, particularly where constitutional issues which are intricately connected to labor matters are concerned. The employer-employee relationship is broad, and the ELRC should have latitude to determine employment-related matters. Employers look forward to meaningful engagements on this matter at a national level. The fourth suggestion is the promotion and improvement in union representation. And here I want to confirm that FKE supports the right of employees to join a union of their choice as envisaged in law. However, the question is whether the proliferation of trade unions protects the interest of workers. This is an issue that requires our attention due to the disruptive nature of having multiple unions, especially in one enterprise. There is also the emerging trend where the demarcation disputes and intra-union disputes are taking center stage as opposed to protecting the interest of workers. Employers are often caught in the middle of these feuds. The reality is that Kenya has a low level of union representation. I believe it's less than 30%, and this is a global phenomenon. So the Federation's position is that we cannot improve the level of union representation by having a multiplicity of unions, and that our vision as a nation of having one union per sector should be our aim. The last suggestion is the need to simplify and expedite collective bargaining agreement registration. We have noted that CBA registration process is now being treated as normal causes in court, where registration can be taken out of the cause list and parties directed to take fresh dates in the registry. We all know that CBAs can only be implemented once they are registered, hence the process should be simplified and expedited. Honorable Chief Justice, FKA requests flexibility in the registration of the CBAs as much as possible where the employer, as the implementing agency, is present in court. We believe these CBAs should be registered for the interest of workers. FKA similarly proposes that guidelines should be issued whereby 1 day per week is designated for CBA registration before one judge. Honorable Chief Justice, my lady, in view of the unique nature of labor disputes, employers humbly request that you consider the creation of the Employment and Labor Relations Division in the Court of Appeal. We believe that this will go a long way in supporting the proper functioning of the labor sector. Lastly, Honorable CJ, Honorable Deputy CJ, judges, distinguished ladies and gentlemen, I want to assure you of the Federation's full support and confidence in the Employment and Labor Relations Court. And we wish this court and indeed the judiciary every success in the next decade and beyond. Once more, congratulations to the ELRC. For the next 10 years, may you see new heights. And we want to appreciate the work that you have done in cutting a niche for yourselves in the administration of justice in our sector. Thank you very much.
Thank you very much, CEO of Federation of Kenya Employers. Thank you for noting the progress that has been made and also challenging all of us as stakeholders in the areas that we can continually improve. At this juncture, let me welcome Dr. Francis Atwoli, who is the Secretary General of COTU, to also make his remarks. Welcome.
Thank you very much. Let me start by recognizing and appreciating the Lady Justice, Sister Mother Koome, Chief Justice and President of the Supreme Court of Kenya, her able deputy, Madam Philomena Mwilu, and as we were told that we must be brief as much as possible, to me recognize the Speaker of the Senate, Brother Amason Jeffer King, and the Governor of this international seat of Nairobi, Honorable Johnson Sakaja, and my own twin sister, Jacqueline Mugo, and all other friends of this court, judges, including Honorable Justice Byram Ongaya, Principal Judge, this very important court. I also recognize all those who have endeavored to come and join us on this very important day. But first and foremost, I would like to thank the Honorable Chief Justice for extending this kind invitation to the Central Organization of Trade Unions in Kenya to not only participate in this important symposium, but also to make contributions to the place of Employment and Labor Relations Code in promoting social justice and economic prosperity. This symposium comes after a few weeks that we had a very, very successful open day by this Employment and Labor Relations Code, whereby COTU Kenya equally participated and contributed to the ideas towards the place the court holds in our democratic space and the role this court has continued to play for now and for the future that this court will be around. As noted during the open day, the Employment and Labor Relations Code holds a special place in our democratic society, considering it serves as the cornerstone of justice for workers, ensuring that their rights are protected, their voices are heard, and their dignity is upheld. So this is a very special court for us and very important court for us. This special and unique space held by this court can only be understood with a clear understanding of the history and evolution of this court. When you see this court being successful, things don't just happen. There is a long history of this court. And this history, maybe it is me only who can narrate it briefly, because I have been around and associated with this court for more than 56 years. I don't think whether we have anybody who has been closer to this court currently more than myself. Because I was firstly elected in labor movement on 3rd of September in 1967. I've been a witness. I've been seeing it personally, this court growing, and that is why this court is specially close to me, and I have done a lot to make sure that this court remains around. The journey of the Employment and Labor Relations Code can be traced back to the progressive labor movements that emerged in Kenya during the struggle for our independence, with workers fighting for their rights and fair treatment in their workplace, while seeking for freedom and social justice at the time. The court has undergone several transformations over the years to enhance its jurisdiction and improve the capacity to handle labor matters effectively. In 1953, the precursor to the then Industrial Code was the Industrial Disputes Tribunal under the Industrial Relations Ordinance Cap 55. Even though the tribunal had limited powers and primarily focused on settling individual disputes between employers and employees, with increased calls for freedom and more rights by the labor movement in 1950s and 60s, the Trade Union Ordinance of 1962 was enacted providing for the settlement of disputes through conciliation and, if necessary, an arbitration panel or a board of inquiry at that particular time. However, on 10th February 1964, through the efforts of the most celebrated African labor leader on the continent of Africa, the late Thomas Joseph Mboya, the Industrial Court was established through a tripartite agreement under the Industrial Relations Act, with Honorable Justice Said Koka being appointed as the principal judge, with both employers and workers appointing their assessors to assist the judge in their decisions. I'm going to this history so that most of the young judges and those lawyers who appear before them might have a little bit glimpse of how and where this court started and where it came from. The Act gave this court the authority to adjudicate on matters related to collective bargaining and fair labor practices, strikes, lockouts, and trade disputes. And in 1965, this legislation was amended where the Act was strengthened, making the court a standalone body. Just to take note, the first presiding judge, the late Honorable Justice Said Koka, was at the time of his appointment a practicing advocate whose firm represented workers under the Kenya Federation of Labor, a precursor of today's Central Organization of Trade Union movement. Justice Said Koka was a brother and a partner to our former Chief Justice, Honorable Justice Majid Koka. Their role was to defend political activists and agitators for Kenya's freedom, including trade union leaders at that particular time. As you may be aware, Africa, Latin America, and Asia, we attained our independence through the struggle of labor movements. And Kenya was ahead on the continent of Africa, spearheaded by those brilliant and gallant Kenyans in the labor movement at that particular time. Note that it was the late Thomas Joseph Mboya, who had just moved to government from Kenya Federation of Labor, that convinced Justice Said Koka to take up the appointment as the first ever presiding judge of the court. And there's no way Kenyan workers then and now can distance themselves from this important court, because we consider this court as our court. Indeed, this court remains the brainchild of the trade union movement in Kenya, and it was constituted to protect the weak. And the weak, under tripartism arrangements, where we have workers, employers, and governments, workers remain to be the weak. With such developments, this court increasingly became an important forum for workers and employers to seek redress, settle grievances, and enforce labor laws, which ultimately contributed to the growth and development of industrial peace and justice in our labor laws and labor relations. Equally, the court became a satellite of reference to the entire continent of Africa, with most countries that had attained independence after us coming to Kenya to learn how this court was constituted and how it operates. In the year 2001, the court was granted wider jurisdiction through amendments to the Industrial Courts Act, whereupon it was empowered to handle matters beyond industrial disputes, including employment, contracts, termination of employment, discrimination, and matters related to the Employment Act. At this point, the evolution that was to follow was direct consequence and demand by us from Kotu, when, for instance, soon after my election as Kotu Secretary General in the year 2001, during the month of August, the appointment of more judges to this court became my priority, my first priority in my work, and I promised my colleagues in my maiden acceptance speech that we would make sure that we empower, we strengthen our industrial court at that time to meet the then challenges workers were facing. And appointment, and this as a priority that we had, I managed to have a meeting with the late President Mwai Kibaki, whom we came together near the same time in leadership, to appeal for more. My meeting with him was to appeal for more judges to be appointed. And on 22nd September, the year 2003, he appointed four more judges, namely Honorable Stuart Mazayo, Edwin Mukunya, Paul Kosgei, and Mtasa Ali Jaffa to assist the then Judge Justice Said Koga, together with Justice Charles Chemtut. In 2007, further reforms led to the enactment of the 5 sets of labor laws that we currently use. And in the 2010, under Article 162 of our Constitution, the Employment and Labor Relations Court was established, marking a big success towards court's evolution, expanding its mandate and equipping it with increased powers to adjudicate on a broader range of employment-related matters. Chief Justice, I want to inform you that in the year 2009, I spent hours holding round-table meetings with the then President, the late President Mwai Kibaki, in the presence of the then Head of Public Service and Secretary to the Cabinet, Ambassador Francis Mudaura, who is still there, and then the then Interior Permanent Secretary, Francis Kimemia, who are there talking about strengthening this court, and who for a long time, Kimemia for a long time, used to be part and parcel of our Labor Day organization. And it is in this meeting that I managed also at the same time to convince the President to accept and to extend the retirement age the currently civil servants enjoy from 55 to 60 years, in line with other East African community member states. We also agreed on several issues concerning this court. This court finally became a specialized institution dedicated to resolving disputes and protecting the rights of both employers and employees. In 2012, 11 more judges were appointed to the court following our 2010 memorandum that we presented to the constitutional experts that time, that made it a fully specialized court, and happily the following were among other judges that we celebrated after their appointment to increase the number of judges with a view of what was also reflected in our memorandum to decentralize this court so that the former provincial boundaries each had 1 or 2. These were Justice Nelson Aboda, Justice Songaya Bairam, Justice Nzioka wa Makau, Justice Monica Mbaru, Justice David Marete, Justice Matthew Nduma Nderi, Justice Maureen Onyango, Justice Helen Wasilwa, and Justice Lynette Ndolo. And this was a big success, bringing justice closer to workers and employers. However, so many appointments have followed, now opening the doors for more judges. And those that I have mentioned now are not only authority in labor relations matters in this country, but they can practice and advise internationally. However, as we commemorate the history and evolution of the Employment and Labor Relations Code and the vital role they play towards social justice and economic prosperity, we must also acknowledge the challenges that lie ahead and challenges that they face in line with the work they are doing to dispense justice. To this end, Madam Chief Justice, we humbly appeal to the separation of roles of the judges so that there are those designated to handle disputes between registered trade unions and registered employers organizations and their members, And then let other judges be designated to handle general employment matters from non-unionized Kenyans, and this will guarantee speedy resolution of disputes in our Employment and Labor Relations Court. That is our appeal, Chief Justice. The court continues to face significant backlog of cases impacting on speedy resolution of labor disputes. Adequate resources must also be allocated to the court to enhance its capacity and efficiency, even as we continue exploring alternative dispute resolution mechanisms such as mediation and arbitration to expedite the resolution of labor disputes. Indeed, it is the Central Organization of Kotu Kenya that pushed the then president, also the late President Mwai Kibaki's government, to allow various government institutions to be attending the International Labour Conference, ELRC. President Kibaki, the late, was very positive for the growth of this court, for strengthening of this court, and also for effective representation in both local and international conferences. And for us to appeal to him that when we have an ILC, International Labour Conference in Geneva, for specific reasons, this court must be represented. Like, for example, the institutions we asked, one was National Social Security Fund as a member of the International Social Security Association, which works closely with the International Labour Organization, must every year be represented at the International Labour Organization. And also participate in employment and social protection committees at the ILO. We also asked for the National Industrial Training Authority, which is part of the ILO's obligation dealing with skills development and prior learning, of which the International Labour has a special interest globally, and lastly, Employment and Labour Relations Court judges, who are very crucial in the two International Labour Organization committees, namely the Standard Setting Committee. That is the biggest debate where we require every year a judge from this court to be attending and participating, because that is where international disputes concerning employers, governments, and workers are debated. And also a committee on freedom of association, where Sister Jacqueline represents us in each and every year. These two committees are very crucial for this court, and we humbly ask you, Chief Justice, always to avail some facilities and funds for this Labor Relations Court to be represented in this international forums. I also, Chief Justice, appeal to you that please think of strengthening and supporting 100% this Labor Relations Court. If there is industrial peace in any given country, then the growth of economy, or whoever, whether it is central government putting some mechanism in place to spur economic growth, it will always be related as per how social partners are really working together and at their various places of work for the purposes of supplementing the growth of our economy, and hence create more employment for our young men and women who are leaving the institutions of high learning. We 100% depend to this Labor Relations Court. I thank you.
Thank you very much, Dr. Francis Atwoli, for taking us through memory lane of this court and the movement, the trade union, and the courts, and appreciate the institutional memory that indeed you have on this subject. At this juncture, let me welcome Ambassador Anthony Mushiri, the chairperson of the Public Service Commission, to make his remarks.
Welcome, Balozi. A good morning to you all. Good morning once again. Well, we were told to be on our best behavior this morning. We are live on TV. My brief remarks this morning will be my best behavior. And just looking at the program, I just noticed we are just about 20 minutes away to the health break. Now, using a judicial pronouncement, the jury is still out there whether we are going to make that health break in 20 minutes. But I will align myself this morning with the protocols that have been observed this morning and recognize the Chief Justice and President of the Supreme Court of Kenya, Honorable Martha Koome, and all protocols observed. It is my pleasure to join you on this occasion of the inaugural Employment and Labor Relations Annual Symposium and Exhibition. 13 years ago, a new constitution was born, and with it, a new way of life in the governance, not only of the country, but also of the workplace. A paradigm shift was introduced, particularly in the management of the public service. However, a lot of water has gone under the bridge, more so in regard to issues of human rights. Within that period, and under the watchful eye of the judiciary, Kenya has become accustomed to fully embracing the rights of the employee that are so enshrined in Article 27 of the Constitution. As a country also, we have in the last 13 years experienced a lot of growth, particularly in the public service, with regard to rights of employees and potential employees. The Public Service Commission, the Judicial Service Commission, the Parliamentary Service Commission, the Teachers Service Commission, and the National Police Service Commission have more or less complied with Article 232 of the Constitution. Where this has been found to be non-discerning, the courts have usually stepped in to correct the situation. However, a lot of work still needs to be done, and this symposium provides a perfect opportunity to address topical and emerging issues. Additionally, and most important for employees, the Employment and Labor Relations Court has, over the years, delivered judgments on the provisions of Article 41 on the right to fair labor practices and Article 47 on the right to fair administrative action. As I stand here speaking for the Public Service Commission, the court's decisions have over time guided us on the review of our regulations and discipline manuals to reflect the said rights and to ensure that employees are provided with fair treatment so as to protect their rights. The incorporation of the court's decisions in our regulations and policies has seen a significant reduction in the number of cases arising from disciplinary control decisions or other decisions affecting employees' rights. I urge the ELRC to continue being alive to this, especially on the issues of non-discrimination. So this morning, as we celebrate the slightly over 10 years plus of the Employment and Labor Relations Court and inaugurate the annual symposium and exhibition, we do appreciate the input of the court, the milestones, and the jurisprudence that has helped to shape employment and labor relations as we know it now. In conclusion, I do appreciate the partnerships that we have had with the court through the Court Users Committee and through other symposia that I have had the privilege to attend on the invitation of the Honorable Chief Justice. This is because the Public Service Commission is a key stakeholder in both the Judicial Service Commission and the Employment and labor relations sector. And we remain, as a Commission, willing to make our contributions in legislative, regulatory, and procedural proposals, as well as in the development of jurisprudence through our regular submissions in court. Once again, my congratulations to ELRC for its 10 years plus of service to this nation, and wish you fruitful deliberations. Thank you, and God bless you all.
Thank you very much, Ambassador Mshiri, for your remarks and giving us a perspective from constitutional commissions. We also recognize you as a critical part in our courts. This juncture, let me take this opportunity to welcome Mr. Eric Theuri, who is the President of the Law Society of Kenya, to come and make his remarks. Mr. Theuri, please.
The Honorable Chief Justice of the Republic of Kenya and President of the Supreme Court, allow me to recognize and adopt the protocols that have been laid out, and just to also confirm that I fear all of you. I wish, on behalf of the Law Society, to take this opportunity to first of all congratulate the court and the planning committee for coming up with such an exciting program for this symposium. And the theme of this discussion, in terms of assessing the place of the ELRC in promoting social justice and economic prosperity, in our view, could not have come at a proper time. But let the Chief Justice, the Employment and Labor Relations Court has recognized the place of employment in the case of Monica Munira and 6 others versus Mount Kenya University. And this is what, my Lord, the court said, that apart from life and land ownership, employment ranks amongst the most emotive issues in a person's life. The failure to secure a job or the loss of one has a direct relationship with a person's confidence, dignity, and place in society. The place of the Employment and Labor Relations Court, but it was also extremely tested during the COVID period, when the court was placed in a very, very difficult situation of balancing employee rights vis-a-vis the survival of businesses and the frustrations that arose from the containment measures that had not been anticipated by most businesses as they made the plans. And so at that particular time, this court was severely tested, but it behaved, in my view, admirably well, because it was able, in most instances, to balance those extremely competing interests. My Lady the Chief Justice and this honorable gathering, we've also seen jurisprudence from the court, and some of these cases have been affirmed at the Supreme Court. And the one that I note that is of significant importance is the case of Samuel Gitau versus Package Insurance Brokers that went all the way to the Supreme Court with on the question of indirect discrimination and reasonable accommodation of employees who are sick or suffering from one form of infirmity or the other. I think looking at the jurisprudence that has emerged from this court, we've been able to have several decisions and quite a number of decisions that have gone towards promoting social justice and looking at the aspect of how to balance industrial peace at the same time sustaining economic growth. And so we therefore join hands with all those who have made their comments here in congratulating the court on these achievements. As the Law Society, we pledge that we will continue to work with the court through the court users committees to advance justice and to see social justice through the work that the committee does. May I take this opportunity also to congratulate the team that was representing the Law Society in the planning conference. I see the chair of Nairobi branch, Ms. Helen Namesi, my council member, Mr. Wora Kabata, the vice president also of the Law Society, for the work that you have put in ensuring that we have quite an impressive symposium, and we look forward to the discussions that are going to be held. My Lady, with those very, very few remarks, I wish each and every one of you wonderful deliberations. Thank you.
Thank you very much, President LSK, for your remarks and whetting our appetite on the question of jurisprudence. On the fourth day, we'll have an entire session that is dedicated to looking at the jurisprudence that the court has developed over the last 10 years. So that is a session to really look forward to. At this point, I have the pleasure to welcome the Honorable George Murugara, who is a member of Parliament and the chair of the Justice and Legal Affairs Committee of the National Assembly, to make his remarks. Welcome, Mheshimiwa.
Thank you very much. The Honorable Chief Justice, Lady Justice Martha Koome, who is the Chief Justice and the President of the Supreme Court of Kenya, the Honorable Lady Justice Philomena Mwilu, the Deputy Chief Justice and Vice President of the Supreme Court of Kenya, and the Honorable Justice Retired David Maraga, Chief Justice Emeritus. The protocol is as laid out. Ladies and gentlemen, good morning. Allow me to make these remarks on my own behalf, on behalf of the Justice and Legal Affairs Committee, and also on behalf of the Speaker of the National Assembly of Kenya, the Honorable Moses Masika Wetangula, who has sent me to represent him here today and join you in the opening ceremony of this great symposium. Allow me to express my sincere pleasure and profound gratitude to the judiciary for the invitation to this inaugural Employment and Labor Relations Annual Symposium and Exhibition, ELRC, to mark 10 years of existence and service by this specialized court to the Republic of Kenya. With humility, allow me to thank the organizers, presenters, and the facilitators of this function for extending an invitation to the National Assembly to be part of the auspicious occasion. Ladies and gentlemen, I would firstly like to acknowledge and appreciate the continuous efforts by the judiciary in innovating service delivery, which signifies that they are in constant modulation in pursuit of excellence in the exercise of their constitutionally designated mandate to exercise justice, which is the shield and defender of the people of Kenya. Today, we celebrate a decade of the Employment and Labor Relations Court, strides in the promotion of social justice and economic prosperity. This is a significant milestone that deserves our recognition and applause. It is a testament to the dedication and hard work of all those who have contributed to the establishment and success of this court. Through this symposium and exhibition, the judiciary and other justice sector agencies will be able to keep the public informed of their activities. Their activities, achievements, and challenges in the administration of justice with regard to fair labor practices in Kenya, and thus provide an avenue for legitimate stakeholder feedback, which in turn promotes public participation in the enhancement of our democracy as envisioned by the Constitution of Kenya. Ladies and gentlemen, as the institution entrusted to interpret the laws of the land as enshrined in the Constitution, the judiciary plays a pivotal role in the stability and the prosperity of our country. I wish to acknowledge and applaud all stakeholders of the Employment and Labor Relations Court, who include but are not limited to the Ministry of Labor and Social Protection, the Salaries and Remuneration Commission, the International Labor Organization, the Ethics and Anti-Corruption Commission, the Law Society of Kenya, the Central Organization of Trade Unions, the Federation of Kenya Employers, the Institute of Human Resource Management, all public and government employment commissions and boards, and not forgetting the legislative arm of the government, the Parliament of the Republic of Kenya, for their efforts towards the realization and promotion of economic, social, and cultural rights at the workplace, and thus promoting the advancement of human dignity. I urge you to continue working together in a bid to realize the judiciary's vision, which is social transformation through access to justice. Through access to justice, plan and operate within a transparent framework. Such a stability is essential for attracting both local and foreign investment, as it gives confidence to potential investors that their rights will be protected within a fair and predictable legal system. However, even as we mark this milestone, we must also recognize that there is still work to be done. The challenges facing our labor market are complex and evolving, demanding continuous efforts to adapt and improve our institutions. It is crucial and we invest in the capacity building of our judges, magistrates, and court staff to enhance their skills and acknowledge employment and labor law matters. This will enable them to effectively address emerging issues and provide speedy justice to those who seek it. In this regard, the judiciary must be commended for recognizing and embracing Article 159(2)(c) of the Constitution of Kenya, which advocates for alternative dispute resolution mechanisms to tackle the backlog of cases across the country. The development of a curriculum with various stakeholders for the Kenya Judiciary Academy to train conciliators, displays the judiciary's commitment to the fidelity to the Constitution. The availability of an increased number of trained conciliators countrywide will ensure that when inbuilt systems in organizations fail to resolve an employment dispute, the tripartite arrangement where employers' unions, the Federation of Kenya Employers, and the Ministry of Labor under the Labor Relations Act will engage in the existing framework for dispute resolution. Ladies and gentlemen, as I conclude, the leadership of Parliament continues to urge parliamentarians to review and update the labor laws of the country to ensure they remain relevant and responsive to the challenging dynamics of our economy. We need laws that strike a balance between protecting workers' rights and creating an enabling environment for businesses to thrive. This requires close consultations and a collaboration amongst the executive, the legislature, and the judiciary, and other stakeholders to develop comprehensive, progressive, and forward-thinking legislation. In this regard, I reiterate that the Speaker of the National Assembly has made a commitment to ensure that this is done, including supporting any legislative agenda that may be brought to the National Assembly by the judiciary, and also including sustained budgetary allocation of the necessary funds to the judiciary as may be. Thank you so much. I wish you a fruitful deliberation. Thank you very much.
Thank you very much, Honorable Murugara, for your remarks and assurance of the continued support to the judiciary, particularly in budgetary allocation to support capacity building and other critical operations that will ensure that the judiciary operates optimally. At this juncture, let me welcome the Honorable Justice George Kimondo, who is representing the Principal Judge of the High Court to make a few remarks. Welcome, Judge.
Thank you very much. My name is Kanye Kimondo. The Honorable Deputy Chief Registrar has decided to baptize me, but I'm okay. The Honorable Chief Justice and President of the Supreme Court, the Honorable Mother Kome, all other protocols observed. I stand here wearing the hat of the acting Principal Judge of the High Court. On behalf of the Principal Judge of the High Court, the Honorable Justice Eric Ogola, and the entire College of Judges and staff of the High Court of Kenya, please accept our very warm greetings. I join all those who have spoken ahead of me in extending felicitations to my brother, the Honorable Mr. Justice Byram Ogaya, the Principal Judge of the Employment and Labor Relations Court, and all the other 20 judges of the court as we celebrate a decade of distinguished service to our people. Your Honors, ladies and gentlemen, during that short period, the court has successfully navigated the rocky stretch between the enforcement of private and public workers' rights and the interests of their employers, those of trade unions and the Employers' Federation, and resolving conflicts between one trade union and another. In doing so, the court has been alive that its decisions have a direct bearing on the growth of our economy, and that it must remain an enabler of economic prosperity. The last 10 years have also witnessed a remarkable growth of a wealth of jurisprudence that has earned the ELRC the true status of a superior court. Hongera sana. The court has also fully embraced the concept of social justice, espoused in the blueprint of the Honorable, the Chief Justice, social transformation through access to justice. This is apparent in the court's deliberate policy of securing the dignity of workers, bringing the indigent and marginalized litigants to the center of the table of justice, and achieving a very high clearance rate in its workload. To further improve on delivery and access to justice, the court has now been devolved to a number of counties. Lastly, this journey has not been without challenges. From a legal standpoint, there has been occasional conflict between the jurisdiction of the High Court, as conferred by Article 165 of the Constitution, vis-a-vis that of the two courts of equal status under Article 162 of the Constitution. Happily, it is purely an issue of sibling rivalry, and sometimes the over enthusiasm of some judges are included in serving Wajiko, Kiplagat, and Otieno. Furthermore, in cases of cross-cutting legal disputes, the Court of Appeal and the Supreme Court have continued to demarcate clearly our boundaries. I want to thank all of you for your attention and to wish you a very successful symposium and exhibition. Asanteni sana na Mungu awabariki.
Thank you very much, Honorable Justice Kimondo. You'll excuse my baptism, but I think it's probably a function of our long history together. You are a very distinguished lecturer in my earlier years in the university, and I remember very fondly my first ever trip to Mombasa with the university students that was led by yourself. So thank you very much. At this juncture, let me take this opportunity to welcome the Honorable Justice Byram Ongaya, who is the principal judge of the court that we're here to commemorate today, to give us his remarks. Honorable Principal Judge.
My Lady Chief Justice, all protocols observed, our most esteemed guests and stakeholders, ladies and gentlemen, good morning. Thank you for your presence today. I'm glad that we have come together as one people in a legitimate platform of sharing experiences, expectations, fears, concerns, feedback, and designing next steps. Our goal is to sustain human dignity through justice, becoming the true shield and defender of our people. This is part of our reflection upon the role of our judiciary since the promulgation of the new republic under the Constitution of Kenya 2010. And it is not just about judiciary, but also all systems of our existence for a prosperous Kenya, for all Kenyans as a people. I thank each one of our stakeholders for the continuing cooperation and support. I thank the judiciary leadership in a very special way, the Honorable Chief Justice for approving and supporting the holding of this inaugural Employment and Labor Relations Annual Symposia and Exhibition ELRC. The Honorable Chief Registrar and the Judiciary Management team have with due dedication and focus worked towards a successful ELRC. And I also thank the Registrar of the Employment and Labor Relations Court of Kenya, the Honorable Kennedy Kandet, and our judiciary staff at the court who have injected tireless efforts to enable ELRC. The Honorable Judges of the court, and our stakeholders have taken several breaks from their very busy schedules to attend meetings to plan for this inaugural ELRC. The stakeholders have participated with keen involvement in pre-ELRC activities, including the open days, the court service weeks aimed at reducing case backlogs, justice matches, the Inns of Courts, the presentation of memoranda to the court by the stakeholders, and the webinars especially involving our universities and professionals. The Judiciary Directorate of Public Affairs, DPAC, has very professionally coordinated the awareness about ELRC, and we have seen this in the radio, television, print, and social media. The Judiciary Police Unit and Judiciary Protocol team have assured our orderly and secure comfort. I thank you. Some of the stakeholders have also been with us in resourcing ELRC, and the Honorable Deputy Registrar have mentioned them, and we thank you all. To all of you, our stakeholders, I say thank you for coming together to make ELRC to materialize. The Kenya Vision 2030 aims to transform Kenya into a newly industrializing middle-income country, providing a high quality of life to all Kenyans by 2030 in a clean and secure environment. The vision was launched by His Excellency President Mwai Kibaki then on 10th June 2008. The vision is based on the economic, social, and political pillars. The economic pillar aims to improve the prosperity of all Kenyans through an economic development program covering all regions of Kenya and aimed to achieve an average gross domestic product GDP growth rate 10%. It was hoped per annum beginning 2012. The social pillar seeks to build a just and cohesive society with social equity in a clean and secure environment. The political pillar aims to realize a democratic political system founded on issue-based politics that respects the rule of law and protects the rights and freedoms of every individual in Kenyan society. One of the key foundations of the vision is an efficient, motivated, and well-trained public service. The public service is envisioned to be more citizen-focused, results-oriented, that values transparency and accountability to the people. The constitutional initiative was one of the vision's flagship projects, which resulted into the completion of our Constitution 2010, together with its enabling legislation. One of the legislations was the enactment of the Employment and Labor Relations Court Act 2011. The other flagship project under the political pillar was judicial and legal reforms, initiatives involving reforms relating to the rule of law and reforms in government institutions in the three branches of government. The ELRC, this symposium and exhibition, is part of the continuing national conversation about implementation of the Kenya Vision 2030 and the Constitution of Kenya 2010. It offers an opportunity in the immediate narrower sense to reflect upon the role and impact of the judiciary, and in particular the ELRC, since its establishment over 10 years ago. In the wider sense, we will re-examine the progress in implementation of the vision's social, political, and economic pillars. I say these things to reassure Kenyans that the honorable judges, in the many disputes that come before the courts, are at all times alert to the historical, constitutional, social, political, and economic aspirations, expectations, experiences, and hopes of Kenyans. I thank the honorable judges for their dedication and undertaking to do justice at their best in every dispute that is brought to the courts. The role of the court is to foster rights, freedoms, and obligations of the employees and employers in a fair, expeditious, and proportionate manner. The Honorable Chief Justice has established 3 divisions of the court: the Appeals Division, the Claims and Labor Relations Division, and the Judicial Review and Labor Rights Division, which have become operational since March this year in the Nairobi Court Station. The division of the court's workload, together with the judicial docket management system, are envisaged to accelerate the court's excellence in judicial service delivery. The honorable judges have impressed the judicial docket management system, under which each court's workload is delineated, enhancing flexibility, consistency, coherence, and efficiency in case management. The court has also impressed the judiciary digital strategy, entailing e-filing of cases, case tracking system, the virtual courts. We have submitted ourselves to accountability and transparency through signing and implementing the Judiciary Performance Measurements and Understandings, PMMU, which spell out our performance targets and monitoring and evaluation systems. During this ELRC, our stakeholders will see the PMMU reports over the years, and which shows that the ELRC is on a fast lane to becoming a champion in judicial service delivery, free from case backlogs. I thank the honorable judges and our judiciary officers for implementing strategies that have improved case clearance and reduction of case backlog. As at the end of March 2023, the total pending cases in the ELRC across the country per the judiciary case tracking system was 10,162, with the highest being at Nairobi Station, 7,875. I'll not enumerate the statistics because you'll have a chance to look at them. The Honorable Chief Justice has established sub-registries in Kitale, Garissa, Voi, Kisii, Siaya, Nyamira, Machakos, Voi, and Thika. The coming into effect of all these sub-registries and establishment of further sub-registries is predicated upon increased resourcing of our judiciary. The spread of the court across the country in all our counties is expected to enhance access to justice as envisaged in the Constitution and the Judiciary Vision social transformation through access to justice. The court recognizes that alternative dispute resolution will go a long way in enhancing stable and fair work environments. As a court, we celebrate ADR as a necessary executioner of case backlogs. We trust that internal workplace mechanisms, as well as constitutional, statutory, or traditional practices of strategic negotiation, mediation, conciliation, arbitration, and others should be exhausted prior to invoking the court's jurisdiction. In that realization, the Honorable Chief Justice will soon be launching the training manual on conciliation curriculum as developed by the Kenya Judiciary Academy. The manual's implementation is expected to accelerate and intensify use of conciliation as the priority process of resolving employment and labor relations disputes. The court's rules of procedure are under constant review for more access, justice, as well as efficient and effective case management. The Rules Committee is at the tail end of reviewing the current rules of procedure for validation and publication later in the year. The work of over 10 years in the new republic under the Constitution of Kenya 2010 has indeed seen strides in justice and jurisprudence in labor relations, employment, and dispute resolution. Emphasis has been on fairness rather than arbitrariness at the workplace for both employer and employee. The subjects have been wide, very refreshing, very engaging. The catalog is long, but let me mention the already mentioned jurisdiction of the court, freedom of association versus unionism, principle of one industry sector, one union, diplomatic immunity, demise of the pleasure doctrine in public service, the scope and content of the right to fair labor practices, scope of the employment relationship, employer, employee, the piece rate workers, and what we call gang workers, digital and virtual work and workspaces, governance of employer, and employee association, remedies in employment and labor disputes such as reinstatement, compensation, re-engagement, conservatory orders, injunctions, structural interdicts, ensuring constitutional or statutory obligations are not unreasonably neglected to the disadvantage of achieving particularly the socioeconomic rights and freedoms and declarations, unionism, and solidarity versus full disclosure, informed negotiations, and free contracting, information and implementation of employer-employee relationship, protection of children and freedom from child labor, gender rights and mainstreaming rights of persons with disabilities, the whole realm of rights and freedoms in workplace, voluntary service, internship, training workers, arrangements that look like employment, such as directorships, liquidators, and trustees. The list is long. The workplace is fast changing. The court envisages growing litigation and development of deep and rich jurisprudence in employment and labor relations, social justice movement to protect vulnerable groups such as the disadvantaged men and women, such as in incomplete or dysfunctional contracts of employment, children, persons with disabilities, and those in informal employment or even modern-day slavery, is anticipated to trigger strategic interest or public interest litigation. A constitutional approach to work and workplaces characterized with enforcement of constitutional obligations, values, principles, rights, and fundamental freedoms constitute a forest of cases that will go beyond the traditional contract of employment. The disputes are as well envisaged to be about the delivery of human sustainability, about skilling, development, and reskilling and retraining for a human capacity to serve the rapidly changing content or nature of work and methods of working to achieve sustained enterprises for the well-being of the individual workers, families, communities, and the entire society. To mitigate stresses associated with working and search of livelihood in a world of ever-changing household budgetary demands, focus will be about work-life balance for policies that support employees, offer flexibility in work arrangements, support remote working, recognize short-term employment, supporting workers' physical and mental well-being. Social protection systems will need to be redefined and redesigned to mitigate vulnerable workers being prone to poverty, defenselessness, and social risks of unemployment, exclusion, sickness, disability, and the inevitable old age. The impact of technology with readily transboundary work relationships accompanied with faceless or invisible or multi-employers and employees will require a redefined theory of employment relationships. We anticipate a future of completely redesigned formulation, interpretation, and implementation of workplace laws and policies, such as about formation of a contract of service, owner of a workplace and work, content that constitutes work, performance requirements or systems, how to enter and exit employment, and distribution of employment obligations, prerogatives, rights, benefits, and liabilities. The policies and laws for a fair contract of service or fair work relationship will need to innovatively consider addressing full disclosure by parties versus collective bargaining or both as the mechanisms for assuring fairness for both the employee and employers. The Honorable Chief Justice's approval of the holding of the Employment and Labor Relations Annual Symposium and Exhibition, ELRC, is indeed a timely intervention for fostering innovation in employment and labor relationships laws and policies. As a court, we seek to enhance our appreciation, not only to learn new things, but also to rediscover new ways of learning for more just, proportionate, and expeditious resolution of the disputes. And the objectives of the ELRC have been spelled out in the programs which you have already seen. Should my Lordship, the Chief Justice, I thank you for this opportunity that the court can interact with our stakeholders. Ladies and gentlemen, I thank you and welcome.
Thank you very much, the Honorable Principal Judge, for giving us a synopsis of the length and the breadth, really, of the ELRC court. And I'm sure as we sit here in the next 4 days, we'll break down the issues that you've talked about, the focus of the court, the jurisprudential issues, and the operations of the court over the last 10 years. At this juncture, I have the pleasure to welcome the Honorable Justice Dr. Smokin Wanjala, Supreme Court Judge, and also the Director of the Kenya Judiciary Academy. Honorable Judge, welcome.
The Honorable the Chief Justice and President of the Supreme Court of Kenya, please allow me to also adopt the detailed protocol that was laid out by the Deputy Chief Registrar. Allow me also to take cue from those who have spoken that we are under pressure of time, but for me it's not a burden anymore, because speaking after Dr. Twali has spoken in matters labor, Jacqueline Mugo matters employer, the Law Society has spoken, the High Court, the National Assembly, and the principal judge of this very court, whose 10th anniversary we are celebrating. What is left for me to say, without running the danger of repeating what has been said, and in the process suffering the ignominy of irrelevance? So I will really be very disciplined in that regard, Honorable Chief Justice. You know, it's an interesting dynamic, because we are being told on the one hand that we are here to celebrate 10 years of the Employment and Labor Relations Court. But then when Dr. Twali spoke, he mentioned another year associated with the beginnings of this court in Kenya. He mentioned 1956. 1956, and we are saying that we are celebrating 10 years of this court. That's an interesting dynamic. So on the one hand, we are really celebrating a very old court, very, very old, because it's associated with our struggle for independence. But then we are also aware that we are talking about a court that became fully fledged court in terms of being a court of the status of the High Court within the context of the 2010 Constitution. I think that resolves that dynamic. So then, having said that, let me then also join all those who have spoken in congratulating the principal judge and your court for organizing this very, very glamorous assembly, and to enable us to really reflect upon what the court has done in contributing to social justice and economic development of our country. You have already told us about what has happened, but one thing Dr. Twali forgot to also mention in that elaborate historical outline of this court is that critical in the recruitment of the group of 12 was Justice Smokin Wanjala, who at that time was a member of the Judicial Service Commission, but most critically, the chairperson of the Human Resources and Management of that commission. So I chaired the interviews of that group of 12. So please, Dr. Twoli, revise your paper accordingly. And let me just also say that I have observed with admiration the gusto with which judges of this court have taken up the challenge, have taken up the burden of navigating between ensuring that the dignity of the Kenyan worker is protected, but at the same time, the buoyancy of the employment sector is also not affected. And this is what I think Jacqueline was speaking to. This is a transformative role, but it is really, really dictated by our constitution within the context of the global matrix within which employment, human rights, trade unionism plays itself. And really, this court has taken up that challenge very, very admirably. As the director of the Kenya Judiciary Academy, I'm happy that the principal judge and the organizing committee took up the advice given to it by the academy in terms of how to organize the discussion environment. I can see that you have taken the mode we advised to interrogate the pertinent selected topics, direct engagement, roundtable discussions, and I hope when we talk about roundtable discussions, we shall indeed have round tables, because this is effective in discussing the history, the role of the court, the jurisprudence that has been generated by the court. Honorable Chief Justice, with those few remarks, I wish the organizers and the participants in this symposium a robust, fruitful, and effective discourse. Thank you.
Thank you, Honorable Justice Dr. Smokin Wanjala, for those remarks, and indeed for the critical role that the Kenya Judiciary Academy plays in building the capacity of the judges of not only this court, but the other courts and also our judicial officers. At this point, let me have the pleasure of welcoming the Honorable Justice Retired David Maraga, Chief Justice Emeritus, to make his remarks. Honorable Chief Justice.
Thank you very much, Mr. Ndemo, the Deputy Chief Registrar of the Judiciary. The Honorable Chief Justice of the Republic of Kenya, Lady Justice Martha Koome, all protocols observed as we were instructed. I wish to thank you, Honorable Chief Justice, for the honor of the invite to join you here this morning on this auspicious occasion of celebrating 10 years of the Employment and Labor Relations Code distinguished service to this country. The theme of the symposium is the place of the Employment and Labor Relations Code in promoting social justice and economic prosperity. Human beings, being who we are, conflict in any relationship is inevitable. Indeed, one writer has said that conflict is integral in all relations. Another one has added that in labor relations, conflict is necessary and functional as a catalyst to prevent stagnation in the workplace. The labor relationships are complex and unique. One aspect of this complexity is the nature of the labor contracts themselves. Besides the fact that the employment contracts do not embrace the principle of consideration, which is common to other ordinary contracts, in employment contracts, the employers dictate the terms of the contract. The other unique aspect of the labor contract is the doctrine of commonality of interests. Though commonality of interests is basic in all relationships, it is unique in the labor relations. Both the employer and the employee have conflicting interests as well as mutual interests at the same time. The employer looks forward to a thriving business, while the employee has the legitimate expectation of being able to earn a salary and advance his career growth. To achieve that, both of them have an interest in the continued profitability of and the existence of the undertaking they are engaged in. This commonality of interest is equally important to government and the business community. Government wants businesses to thrive, for it to levy taxes in order to manage state affairs. No sector of the business community can operate in isolation. As such, all hanker for a thriving business environment. The quartet, therefore, requires a conducive environment that advances efficiency in business relations. To administer this unique relationship requires unique expertise and specialized knowledge. The management of business affairs of an assemblage concourse of people with diverse cultures, ideologies, and backgrounds, and at times operating in turbulent environment, is what I believe necessitated the global establishment of the industrial courts. In Kenya, as we know, the Employment and Labor Relations Court was established under Article 162(2) of the Constitution as a superior court and vested with the jurisdiction to hear and determine disputes relating to employment and labor relations. It was operationalized by the Employment and Labor Relations Act of 2011 with the primary objective of facilitating just, expeditious, efficient, and proportionate resolution of labor disputes. The Constitution sets out fair labor practice as the overarching principle to guide the adjudication of labor disputes. So the foremost role of the ELRC is to handle labor conflicts constructively and promote industrial democracy. The principal role of the ELRC is to ensure that industrial conflicts do not escalate into unmanageable proportions. If labor relations are well managed, there will be industrial peace, which in turn will encourage production. The reverse is disruption by industrial go-slows or outright strikes. In the circumstances, the handling of human capacity development, management and development is critical in an organization. Kenya cannot and does not operate its business transactions in isolation. We are foreign investors with a number, though limited, of foreign workers in this country. To take care of those and local interests, the second role of the ELRC is to develop a robust and predictable local jurisprudence to govern business transactions. This requires the judges of the ELRC to interrogate comparative jurisprudence and, where appropriate and desirable, infuse into our legal system emerging international legal principles in labor relations law. The third, and for me, for my purposes today, final role of the ELRC is to promote reconciliation through alternative dispute resolution mechanisms. With the soaring unemployment rates, especially among the youth bulge in our country, every effort should be made to sustain employment contracts. ELRC is therefore obligated to promote ADR, especially reconciliation in labor relations, as required by Article 159(2) of the Constitution. All these factors demonstrate that the Employment and Labor Relations Code is the linchpin of industrial democracy, without which the moral foundations of the state economy will be at peril. A vibrant and sound employment and labor relations code as a machinery for social dialogue is a critical enterprise in the realization of the workers' welfare and economic stability of a nation. I'm happy to note that as part of the celebrations of the Employment and Labor Relations Code 10 years of distinguished service to this country, the court has brought together its stakeholders to reflect and share their experiences, as well as give forward what they would like done by the court. This is great, and I wish to congratulate the Principal Judge, Justice Ongaya, and your judges for making this opportunity so that the stakeholders can give you their views as you also show them what you have done. I want to believe that at the end of this symposium, both the court and the stakeholders will see the places, their parts that they need to play so that we can continue to enjoy industrial peace in this country. With those few remarks, I want to wish you a very, very successful symposium. Thank you very much for this opportunity.
Thank you, CJ Emeritus, who has spoken with the wisdom of an elder and the reflective punch of a long-serving judge, and also Justice Smoking Wanjala for speaking with his usual intellectual punch. He's always able to mine the important point through the rubble. Thank you very much, Prof. The Court Secretary General gave us the historical point of 1956, and it just occurred to me that the court is older than the Legico, which was set up in 1957. Thank you, Francis Atwoli, for that data point. We are now crusading to the end of the opening session. And as I do that, I would also just want to recognize the founding principal judges of this court, Justice Maureen Odero and Justice Ndumanderi. If you could just rise so that we can acknowledge you for laying very strong foundations for this court. Remember the struggles with Justice Ndumanderi was the first principal judge, and then followed by Justice Maureen Onyang. Thank you very much for the foundations that you laid. It is my pleasure to invite the Governor of Nairobi County, Honorable Johnson Sakaja, to come and speak to us. Governor.
Thank you very much. The Chief Justice, Honorable Justice Martha Koome, allow me to also associate myself with the protocol already established, but allow me to recognize and honor the Chief Justice Emeritus, David Maraga, a man I deeply respect, and who is currently one of the few examples of what it means to support your successor. An example our country currently needs, is in dire need of. Ladies and gentlemen, good morning. It is a great pleasure to join you today and to join in this reflection and discussion. Let me thank the judiciary for inviting me to the symposium, and let me thank all the other panelists and participants for joining us. Allow me to offer the apologies of the Chair of the Council of Governors, Her Excellency Governor Anne Waiguru, who I am equally representing. Today I wear different hats, not just as your host governor or representative of our esteemed chair of the council, but also as the chair of the Committee on Human Resource at the Council of Governors. I also acknowledge the presence of former Governor of Kilifi and the Speaker of the Senate, where I served as a senator and chair of the Labour Committee there for the last 5 years. Ladies and gentlemen, our Constitution will be 13 years old next month. And perhaps we should no longer call it the new Constitution, since it's now the settled order of things. We have had 3 presidential elections and countless more further positions under it, and distributed trillions of shillings in devolved funds to the counties. It is now clearly the established law of the land. It would be easy to fall into complacency now that we have it, now that it is here, we can rest, and that would be a grave mistake. This Constitution was hard-won. It's the fruit of more than 2 decades of intense politics. Hopes were often dashed. Agreement sometimes seemed impossible, but we got it done in the end. And I speak with some passion because I was among those who did my small part at the tail end of the process during the Naivasha Parliamentary Select Committee process to get the entire project across the line. Our struggle, mine and yours, was rewarded with a new republic. Now that we have it, ladies and gentlemen, it is my job and yours to protect and extend the rights and freedoms that we won together. The Council of Governors, which I am glad to represent today, warmly appreciates the commitment of every institution represented here to that absolutely vital national goal. The Council is created and animated by that devolving spirit of the Constitution. That basic conviction that we will have justice, equality, and freedom if we share power instead of hoarding it. We governors and members of the council have any number of different political and policy views, but we share that rock-solid commitment to devolution. We appreciate that today we are among allies and friends who share that basic conviction with us. We're especially glad that the 2010 Constitution established an independent judiciary with authority to interpret the Constitution for us all. The judiciary's wise use of that authority is one of the reasons why the new Constitution has endured. Indeed, it's one of the reasons why devolution has taken the form it has now. The jurisprudence developed over the last 3 iterations of devolution have strengthened our exercise of this great mandate to the people of Kenya, where the different levels and arms of government are increasingly seeing each other as partners and not as competitors, as we saw it especially in the first term of devolution. And we keep saying the national government needs the counties need the national government, the 3 arms of government, the judiciary, parliament, and the executive must see themselves as partners. Of course, this doesn't mean that we always agree with every exercise of the judiciary's authority. There are times that we will disagree with a particular decision. But today I'm very pleased to have listened to the principal judge, Justice Baira Mongaya, passionately mention the judiciary's role in the protection of the vulnerable in society, including children and vulnerable families, which makes me now less worried about the recent temporary orders against our plan to feed 250,000 vulnerable children in Nairobi. And I will be calling you, Justice, as a witness. Thank you. Despite several decisions that we may not always agree with, looking back on the whole body of the court's work since the new Constitution came into force, I think we can all be grateful for the judiciary's good sense. Now, ladies and gentlemen, our counties are collectively amongst the largest employers in the country, and so inevitably we call on you frequently. in settling conflicts arising from employment in the counties, the Employment and Labor Relations Court has emerged as an important player in county governance. In particular, your work in interpreting, of course, the laws in the context of the Constitution and registering the collective bargaining agreements between trade unions and the county governments and the public service boards, and supplying checks and balances where there has been non-compliance with the law has been exceptionally important. But even here, I think we can do better. And a major challenge for county governments has been the unprecedented industrial unrest, especially in the health sector. Often the ELRC has held that strikes were not in line with the law, and time and again the courts have implored on parties to exhaust alternative forms of dispute resolution as envisioned under Article 159(2)(c), which has been mentioned by many speakers, including Honorable Murugara and the Chief Justice Emeritus, that emphasize the importance of dialogue between parties to sort out dispute. What I would wish for is a deeper engagement with alternative methods of dispute resolution, of course all this with the advice of the judiciary, so that labor disputes like these can be solved before they ever come to court in a contentious way. And I'm glad to see Robert Duba and more representatives of the trade unions, of course not forgetting Dr. Francis Atwoli. Maimze, thank you for your remarks. We need to do this without sacrificing the rights of either Kenyan workers or the public that they serve. It's a fine line to walk, but I and the fellow members of the Council of Governors would like to try. Let's make sure that we solve these disputes early and with as little fuss as possible. And additionally, and I support the remarks by Jacqueline Mugo of the Federation of Kenya Employers, when she gave an example of a company that had to close down following a judgment made by the court leading to a greater loss of employment. You know, on behalf of county governments, we would implore a greater appreciation of context when making decisions which invariably have huge budgetary implications or a wider ripple effect on other cadres of employees within the public service, Honorable Chief Justice. Right now, counties are struggling with quite a number of unimplementable CBAs and judgments, and we really need to renegotiate. And we hope that we can have, a way to do it alternately out of court, and I'm leading that cause at the council. I want to close with praise and reassurance. The county governments deeply value the work that you and the institution and those who support it do. We appreciate, Honorable Chief Justice, your ardent defense of the Constitution, your defense of the rights of ordinary Kenyan workers, and your defense of devolution. And that is why we're committed, not just to maintaining, but to strengthening our strategic partnership with the judiciary, so that justice may indeed be our shield and defender. And that is why we reaffirm today the MOU between the Council of Governors and the National Council for Administration of Justice, whose objective remains the improvement of the administration of justice under devolution. And that is why, ladies and gentlemen, I would like to invite you all to join me in congratulating the Chief Justice and in looking forward to a new era of even closer cooperation between the Council of Governors, the county governments, and the judiciary to protect the rights of workers and citizens in the counties. Asanteni sana na Mungu awabariki.
Thank you very much, Governor Sakaja. When we sat the governor at the back there, we didn't ghettoize him. We wanted him to have a very comprehensive view of the high table and the plenary, so that it doesn't evict us from the city. But Governor, thank you. Leadership is about humility and is about service. And thank you for being here and for your speech. Kindly receive the apologies of the Minister, the Cabinet Secretary for Labor and Social Protection, Honorable Florence Bore, who had to attend to an urgent meeting, so she passes her apologies. Ladies and gentlemen, let me now invite the Speaker of the Senate, Honorable Amason Jeffer Kingi, to make his remarks. Welcome, Speaker.
Respecting the directive given by my former schoolmate, the Honorable Paul Ndemo, I will align myself with the protocols given to us by the speakers who spoke before me, but acknowledge indeed the Chief Justice and President of the Supreme Court of Kenya, the Honorable Justice Martha Koome, and go straight to my remarks. However, before I make my remarks, a friendly advice to my lady, the Chief Justice. When you invite us to these functions, kindly indicate the time within which we should make our remarks, because if you don't, you will run the risk of being entertained into very long speeches like the one you're just about to be entertained into. I didn't get the memo about keeping it brief, and therefore what I'm holding here is a 2.5 speech, 2.5 hour speech, putting in danger not just your health break, but also your lunch hour. I'm indeed greatly honored and pleased to join you this morning for the official opening of this symposium. As you're all aware, this event has been organized by the judiciary under the distinguished leadership of my sister, the Honorable Martha Koome, the Chief Justice and President of the Supreme Court of Kenya, to mark the first decade of existence of the Employment and Labor Relations Court. This is a milestone that we are duty-bound to observe with adulation and great appreciation, given the highly commendable work the Employment and Labor Relations Court has done, and which underlines its position as a critical cog in the wheels of justice in this country. Similarly, this is an ideal moment to collectively review, make an assessment, and pick out operational challenges and hurdles that this court has faced in the last decade and continue to grapple with. We can then seek to address them to enhance the court's efficiency and effectiveness and enable Kenyans reap the intended benefits from its operations as an institution. The noble intention is well captured in the theme of this meeting, namely Employment and Labor Relations Court at 10, the place of Employment and Labor Relations Court in promoting social justice and economic prosperity, and the accompanying sub-theme, that is a decade of encounter with the right to fair labor practices, stakeholder experience. Based on the foregoing theme, I'm fully persuaded that we're in for very robust and enriching engagements that will culminate in practical and actionable resolutions with impactful outcomes. I note with keen interest that a session in the symposium is specifically dedicated to interrogating of employment and labor dynamics in the context of county governments. Topics to be canvassed include principles and practice governing county public service boards and interaction with county executives, evolution of resource practice in devolved governments, and the role of Salaries and Remuneration Commission towards realization of sustainable county public service workforce. As the Speaker of the Senate, which by dint of Article 96 of the Constitution is mandated to offer stewardship to devolution, I greatly commend the symposium organizers for the wisdom that informed this decision. Ideally, it goes a long way in confirming that a significant number of key actors are in sync with the reality that devolution is indeed an integral part of our lives as Kenyans, and whatever governance processes we embrace at the national level must be replicated in the devolved units in fulfillment of the aspirations embodied in Article 6 and the entire Chapter 11 of our Constitution. The Employment and Labor Relations Court is established under Article 162(2)(a) of the Constitution of Kenya 2010 and effectively operationalized under the Employment and Labor Relations Court Act number 20 of 2011. As the apex arbiter in resolving disputes arising in the employment and labor arena, this court has been instrumental in entrenching stability in a fluid labor sector guaranteeing sustained economic activity and productivity. This has been achieved through a firm commitment to the rule of law and delivery of judicious and timely decisions that have not only placated aggrieved parties, but also expanded our jurisprudence. Permit me to invite you, dear delegates, to join me in commending the honorable judges and judicial officers of the Employment and Labor Relations Court for a job well done, and pray for them to maintain this very progressive and trajectory and commitment in serving the people of Kenya. Tunasema asanteni sana.